All right, very good morning. It's the second day of the month of September 2022. Welcome. This is Kirk in the morning, and my name is Chris Sambo. So much that we'll be talking about in the next few minutes as we seek to debunk on what transpired yesterday. Ruto lawyers and those of IBC putting in a spirited repulse of the petition filed by the Azimio la Umoja, that is Raila Odinga and Martha Karua. Their submission yesterday and responses raising a lot of questions on what exactly will be the outcome of this particular week in what we expect to be a climax of a presidential petition that was filed by the Azimio la Umoja, that is Right Honorable Raila Odinga and Martha Karua. Of course, there were some issues presented, the issues of the technology used by the EBC in conducting the election, as well as the numbers. Did the president-elect cross the 50+1 mark? That is a question that is still in the court, and the court are getting different responses before they make their verdict on Monday, as well as did the IBC follow the constitution in conducting this election. So those are some of the issues that have risen in the Supreme Court this week, as we also wait to see what the judges will be talking about today, and also what they will give as their ruling come on Monday. So welcome aboard. This is Kirk in the morning, and as usual we take a review of what is in the newspapers, even as we get to talk about few issues that were raised by the respondents' lawyers yesterday, even as the petitioners today get time to file their rejoinders, and also the Supreme Court to declare itself even as they resolve to go and write their ruling. So first things first, this is the newspaper review. All right, and just to take a look at what the newspapers are talking about this morning, just want to introduce my guest here in studio this morning, Biko Ashoya, who is an advocate of the High Court of Kenya. Welcome once again this morning, and good to see you this Good Friday.
Good to see you too.
All right, and just want to begin with the Daily Nation, of course, talking about issues that surrounding the presidential petition. The Daily Nation on its top page talks about what the EBC lawyers led by former Attorney General Githu Muigai and Senior Counsel Fred Ngatia talked about in regards to their response on the petition filed by Martha Karua and Raila Odinga. That is talking about Chebukati is a hero. That is what the lawyers told the court. William Ruto's legal team pulls all stops to paint the picture for a robust and impenetrable poll management system at the IEBC. Scoff at claims by the Raila camp that results forms were intercepted for alteration, and insists that the numbers show that Wafula Chebukati was right to declare the election in favor of their client. That is what the lawyers told the court. And just at the bottom page of the Daily Nation talks about the different submissions by the 7 lawyers representing both Chebukati, the IEBC, and also William Ruto in regards to the presidential petition. And just to pick out what Senior Counsel Kamau Karori talked about, that this is the first time a person is being criticized for being too open. IEBC is now being vilified for being too transparent in uploading result forms, of course justifying the technology used by the IEBC in conducting this year's election. And Professor Githu Muigai, who is the former Attorney General and also the counsel representing IEBC, talking about and saying, this petition is ultimately about numbers. The petitioners have tried to argue every other point except numbers. We conducted a proper, fair, legal, and impartial election. That is Githu Muigai on his highlight statement, what he told the court, that IEBC conducted a fair, legal, and impartial election. And just to quote Fred Ngatia on what he submitted to the court in his response to the petition, he said that it is time for finality and stability. He will be sending a message to the political class that the country does not belong to them. It's for us all. That was his submission, largely talking about what the Supreme Court should do now and going forward. They need to put a closure into what we have been seeing in every election. That is what the Daily Nation talks about on its top page, and going on, and also involving the different arguments, the 50+1 argument, the technology, Chebukati's role, and also the numbers. And just to get in touch with you, Biko, in regards to what the Daily Nation is talking about.
Yes.
Very eminent issues coming out here, and also what the petitioner has touched on. But the respondents put in a spirited repulse on that petition, citing their position. If you look at what the IEBC position was, is that we conducted a free, fair, legal, and impartial election. If you look at William Ruto's defense team, also talking about the chairman was in his right mind and also in his right position to declare a presidential elect with a 50+1. First of all, what do you make of the submissions this week by the petitioners and also the responses yesterday?
Thank you so much. It's my opinion that the advocates representing both parties in the Supreme Court presidential election petition adequately prepared themselves in the circumstances that they find themselves in. Remember that they have been constrained of time to ensure that they, within 7 days for the petitioners, put in petitions, the various petitions for their clients, and the respondents had 4 days to put in their responses. So I think in the circumstances that they found themselves in, counsels for both the petitioners and the respondents actually did quite some good job in ensuring that they brought to the court as much as they could, and within and try to make it as precise as they could to the court, so that they don't budge the court with a lot of irrelevant materials and issues. So I think both teams did quite well in the preparation before they came to court. Yes.
Major issues coming out. You talked about filtering, what isn't so necessary, and they narrowed down, even despite the Supreme Court putting 9 issues that they would seek to address in that petition. The arguments narrowed down to the 50+1. 50% plus 1, that is the numbers on the score of the presidential elect, and also the technology used by the IEBC, also coming in on the role of the chairman of the commission and also the commissioners themselves, and the bigger picture being that of numbers. How many voters did they vote in the 9th of last month? Yes. And also how many votes were casted and counted, and what was included in the final tally to declare a presidential elect? Those are some of the issues that came out. Looking at the submissions and the submissions made by the petitioners, and also the responses filed by the councils of those of respondents. What do you make of the 4 big issues that were termed to be the elephant in the room? For starters, I would want Kenyans to understand one thing: that the Constitution anticipated that at one point of the electoral process, that a court would be involved. And there is that provision in the Constitution, and that is why there's one time in this session where I stated that the Supreme Court, as it sits right now, is actually performing a political function. It is performing a political function, both a political function and a judicial function. A political function because it sits to adjudicate on a political matter. The Constitution anticipated that an election would ultimately end up in court, and for purposes of a presidential election, it would end up in the Supreme Court as a presidential election.
So much so that as the court adjudicates over this presidential election, it is performing, it is having a twin function of adjudicating a political dispute, but in a judicial forum, right? So, and to that extent, then it is still part of the electoral process. And now to answer your question about the issues that were raised by the Supreme Court, and now what you have called the elephant in the room. You see, when the petitioners approached the court, they came up with everything and anything that they thought would help them overturn the win that had been given to the president-elect. On the other hand, the respondents as well, and because of the limited time that they had, they also tried to bring in as much information as possible to try and dissuade the court from the position that had been taken by the petitioners, right? And so in all that confusion that the petitioners and the respondents had brought in, the court had to narrow the issues so that then there is clarity even as the parties are submitting before it. So what did it do? It came up with 9 issues for determination. Out of those 9 issues that the court came out with, it would appear like there are certain sticky issues that the court seems to be very interested in, and which it is trying to direct the parties to make very specific submissions on those issues so that then it can aid the court in coming up with the final determination. And part of what those very sticky issues are is the issue of whether there was attainment of the 50% plus 1. Remember, in the lead petition, what the judges designated as the lead petition, that is petition number 5, the Raila and Martha Karua petition, at one point in that petition, when you read it, it says that none of the parties attained the 50% plus 1. Remember, in an election, and in the event that there is an election dispute, the 2 cardinal issues that are brought to the court for determination is the issue of the quality of that election and on the issue of the quantity. So when we are talking about the 50% plus 1, we are talking about the quantity. And that is why you saw one of the lawyers for the IEBC was designated more than 30 minutes to highlight to the court the issue of numbers. And he went to great lengths. He even had a PowerPoint presentation to try and make the court to understand that the quantity of the election is not in dispute. That the quantity, that the numbers that the IEBC relied in making the final determination was actually, the IEBC did the right thing. So insofar as the numbers are concerned, both parties raised the issue of the numbers. They disputed the numbers. On the issue of the quality precedes, it comes before the issue of the numbers. Remember, when we are talking about the quality of an election, we are talking from the point of even procurement of the kits that will be used in the election. And that is why you saw the issue of the Venezuelans coming in. That is when you saw the issue of the whole procurement process that comes in before the election. And then, how were these kits handled? We are looking. We want to look at the process, because the process then dictates the quality of the election. Before ultimately now we start adding 1 plus 1 at the polling station, and then it comes to the constituency, and ultimately at the national tallying center. So you would see that some of the judges were asking about the quality, and the issue of the commissioners came in. And when the issue of the commissioners come in, we would want to ask ourselves, what is the role of the commissioners as stipulated in the Constitution? If you look at the Constitution, and I would want us to read more specifically Section 138. Remember, even the judges themselves acknowledge that in the 2017 election, it is is Section 88 of the Elections Act that was majorly in contention. In this election, it would appear like it is Section 138 that is being interrogated the most. And why is it being interrogated the most? It's being interrogated the most because it stipulates the functions of the commission. Remember, at one point, the Honorable Lady, the Chief Justice, was asking, were the commissioners given domestic chores? Were they relegated to the peripheral levels of the management of these elections? And even at one point, Jokindungu was asking, does it mean that the chair of commission wields so much power? Him together with the CEO, that then the commissioners do not have a role to play.
I think
if you look at,
as you explained that, I understand you've mentioned about the question of Jokindung.
Yes.
Still in what you are still answering, we can listen in on what she asked,
right?
And as you continue also to answer that question, so we can just take a listen in on what Jokindung exactly asked in what Biko is responding to.
Very well.
And what is the role of the other commissioners? I think this is bothering me, especially because it seems to me that your client and the IEBC suggest that the chairperson works with the CEO, and I feel a bit concerned. The CEO is not vetted by Parliament. He is appointed, but he seems to wield immense powers over and above the other commissioners. I cannot imagine that that could have been the intention of the drafters of the Constitution. So what role do these commissioners actually do? Because it hasn't come clearly. Or, for example, if one commissioner says he's in charge of ICT, what does that mean? Does it mean he's in charge of ICT until the presidential election, then he's not? What does it mean? What is the role of these commissioners? And I'm asking this question more towards trying to understand the leadership and the management in the commission as opposed to the management of the presidential election. Because I think they're two separate issues, and I'm trying to figure out whether this is a Chebukati problem, is it a leadership problem, is it a commissioner's problem? What's this problem we're seeing? I'm trying to understand that, and I'd like to hear that from you.
All right, and that is Justice Njokindung of the Supreme Court raising the question that you were talking about, yes, the functions of the commissions, and yes, she's asking, what is really the problem? So what is really the problem?
You see, that is the predicament that, or rather the uniqueness of the presidential election petition this time round is that we have a commission that is divided. And the problem with that is fundamental, in the sense that we have a commission, an independent commission, that Kenyans have tasked with performing the function that is running of the election. And this commission that we have all entrusted with the running of an election are coming in, one limb of it is coming. You see, when we are looking at it as Kenyans or as an ordinary citizen, I am looking at a commission that is a unit. And so I would be expecting that as they execute the mandate that we have given them as a commission, they would be executing it as a commission and as a unit. And so therefore, if the commission comes out and they are speaking different languages, or the commission is disintegrated, then it speaks so much to the work that we have given them. Remember, at the end of the day, the question that even the honorable judge was asking on when there is a problem between the commissioners, or when there's a problem between the chair of the commission and the commissioners, do we take it as the commission being dysfunctional, or do we take it as it being a problem of the chair alone? Because remember, at the end of the day, the Constitution under Article 138(3)(c), and this is what it provides, that after counting the votes in the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. The wording of this particular section of the Constitution does not say that the chair shall tally and the chair shall verify, tally, and declare the result.
Talks about the commission.
It talks about the commission. So if the Constitution anticipates that it is the commission that will be working in unison, and you see, chair, when we are talking about Chebukati is both the chair of the commission as a commissioner and then the national returning officer. Remember at the beginning, and when the petitioners were putting forth their case, they were saying that the chair gazetted himself as the presidential returning officer. And they were saying that we do not have a position called a presidential returning officer. We have a national returning officer. But then he gazetted himself as a presidential returning officer. But then that is insofar as the terminologies are concerned, and it is neither here nor there. What is of most concern to Kenyans is when the chair decides that he is not going to work with the commissioners, that he is going to work alone. Is he doing that in violation of any law? And I can very authoritatively say, on the basis of the law that we have read under Article 138, that he does not have the sole mandate of verifying, tallying those results. He has to do it as a commission. So when he does it as a person, as an individual,
that
raises the questions that the judges were asking about. It raises that question.
That is matters to do with the commission and the chairman, which is coming out largely, and we'll also be waiting to see what the petitioners put out in their agendas today, and also the response from the respondents' lawyers. That is the biggest issue in regards to the commission. Talking about there was question that were of concern. If you followed yesterday, that there were issues raised by the judges in regards to some of the respondents filed by the defense lawyers.
Yes.
And I just want to pick out Justice Smoking Wanjala.
Yes.
We talked about if at all on the voter turnout announced by the chairman and said it would rise, how relevant is it in determining whether a candidate garnered 50+1? He's talking about when the commission began announcing the results, the percentage of voter turnout was high, but at the declaration of the results, then the percentages seem to be lower.
Yes,
so now he questions on the voter turnout, what numbers would be used in determining, the president-elect, and that is what Smoking Wanjala raised. And then Justice Mohammed Ibrahim goes on and said, would you expect us to make a determination on the chaos that occurred on the National Tallying Center and attribute blame, yet the matter is not before us?
Is not before us, yes.
That is in regards to what IEBC put out on why they were not able, to publicly verify and announce the constituencies in question and in the final tally. So when you look at all those scenarios, when you look at the submissions being made, when you look at how the last minute conduct of the IEBC was in regards to declaring the president-elect, what do you make of such putting the basis of the submissions made before court?
You see, the law provides that, and that is the Constitution, it provides that the commission has 7 days to announce the presidential results from the voting date. And it is a question that was raised by one of the judges. And he was asking the IEBC lawyers, what was the hurry in announcing results on this particular day? And yet there was an extra day. Because remember, the elections were conducted, or rather Kenyans voted on the 9th day of August. 7 days from the 9th day of August 2022 takes us to the 16th day. There was a hurry by the chair of the commission to announce these results on the 15th day. Much as there was a dispute in the commission. The chair comes in through his lawyers and says that we had verified, that the commission had verified the results from the 27 polling stations. But then the lawyers as well come and say that the results from these polling stations were not included in the final tally. What is the commission telling Kenyans? The commission is telling Kenyans that, and I would want to put myself in the shoe of the voter who participated in the exercise in the 27 polling stations. It means that those voters who participated in the 27 polling stations, their vote never counted. Their vote never mattered. They woke up in vain. As a voter who participated in that exercise, in those stations whose results never were
Never factored.
Yeah, were never factored in. They have a legitimate expectation that they woke up very early in the morning and that their vote would count. One thing that the commission is not telling Kenyans, and that they are not telling the court, is what were the numbers from the 27 polling stations? And would this, if they were factored, would they have materially affected or, changed the trajectory of the election? But then fundamentally, and at, the crux of everything is that a political, or rather a decision was taken to not include, whether it is just, whether it is one vote, it interfered with the political right of a voter somewhere. And political political rights are, political rights are sacrosanct because they ultimately determine who becomes your leader. They ultimately determine even the price of unga. So it cascades down to the nitty-gritties of what affects even the economy of the country. My point is, the point that I'm trying to make is that the issue of numbers is very important. The issue of cohesion of the commissioners is very important. It is not about justice being done to the Kenyan people. It is about even justice itself being seen to be done. So if one person would feel that they were disenfranchised at the ballot, it should be a concern to all of us. It should be a concern to the court that the commission is admitting that yes, we announced the final result, but then we omitted 27 polling stations. I would want to presume that if each of the polling stations had let's say 1,000 people times 27, that is 27,000 Kenyans whose vote has not counted or was not counted in the final tally. What does that tell you of the commission?
And how important, or rather how critical is in that regard when one vote that was casted by a voter is not counted? I listened into the judges pose their concerns and their queries to the both lawyers, and they were very categorical when it comes to the voter.
Yes.
Because the Constitution of Kenya has placed the powers on the Kenyan people.
Yes.
They were very categorical in that, for instance, in the petitioner's case, when Lawyer Ndegwa Njiru submitted that the Constitution provides for 290 constituencies, and it goes ahead and says that they should be in the Kenyan territory. But IBC talked about 291 constituencies, including the diaspora constituency.
Yes.
So it talks about where does this constitution and is recognized in the Kenyan law, and raised concerns on but in the questions, Justice Joe Kindungu was concerned that regardless of the constituency that was mentioned by IBC being an extra constituency, we as the court are taking total concern on the voters who voted in that extra constituency that now is being disputed in court. Again, yesterday, talking about the constituencies, the polling station that were perhaps not factored in and the votes not verified by the commission, the court as well raised that issue that if these results were not verified by the commission, then we need to take a serious concern about the same, because these are votes that were casted by the Kenyan voters. So my question would be, how important is it for the determination of the court in regards to just a single vote of a Kenyan voter that was not counted? What impact will it make in the ruling?
I'm saying a single vote in an electoral process is a very important vote. We have had elections being won by a difference of one vote. We've experienced it, even in this country. And so therefore, a single vote is very important in an electoral process. But then even more important is the fact that political rights are rights that are protected in the Constitution. They're not just rights that that are there in statute, but then it is there in the Constitution. And that is fundamental. You bring in the argument by my good friend Ndegwa Njiru about the extra constituency, the extra constituency that that has been factored in all these in this electoral process. The philosophy behind having the diaspora vote being included as a constituency is because they are Kenyans. They are Kenyans. It is only that they find themselves in territories or in jurisdictions whereby they cannot participate in the vote within the constituencies that have been stipulated in the Constitution. And so therefore, and before the diaspora constituency was included, it was actually as a result of a court case. I remember it was in the year, it must have been in the year 2013, 2014, where organizations like Kituo cha Sheria, the Kenya Human Rights Commission, the Kenya National Human Rights Commission, there's another organization. They moved the court to have the diaspora and the prisons to be included. Remember, earlier back in the days, the guys in the prisons never used to vote. And so the directive to have an extra constituency, that is the diaspora constituency, and the prisoners to vote was not something that the IBC moved itself suo moto. It came as a direct, it actually came as an order of the court. Remember, what we are doing as a country, insofar as our election laws and the electoral process is concerned, is that we are perfecting the art as we proceed. The irregularities that we had in 2013, or let's begin with 2007, and it was after this 2007 that we had the Kriegler's report and all that. We are moving towards perfection because of the litigation that we have had over the years. In 2013, the issues that were litigated in 2013 in the presidential election are very different from the issues that are being litigated right now. there was the introduction of the KIMS kit, and it was a result of a court case of the presidential petition. The declaration that the vote at the polling station becomes the primary vote was as a result of an election petition. And so the issues that we are dealing with, even as we move forward, insofar as perfecting the electoral process, is actually issues that have been litigated in court. And so as we proceed forward as a country, we are perfecting, and even most of the regulations that have come in, most of the electoral regulations that, and you've seen most of them being quoted at the Supreme Court, most of these regulations have come in because of the directions that have been given by the court. Right now, most of the litigants and even the counsels that are representing the parties in court are quoting the Raila Odinga 2013, Raila Odinga 2017, the minor, the minor K case. They're quoting those because they have become the basis upon which the IEBC is being directed on how to conduct the elections. So I'm hoping that now that we had the 2013 election petition, we've had the 2017 election petition, we are now having the 2022 election petition. By the time we are getting to the 2027 election cycle, we will have a near perfect electoral process. So that then we will not have all these disputes about, like, remember in 2017, the court directed that the IEBC servers be opened for scrutiny. And the IEBC was so adamant, it never opened those servers until as we are speaking right now. In the 2022 election petition, we're having the same thing. Probably it is time that we can have a conversation about this whole thing that is the IEBC server. Remember, and as you've been watching, as you've been watching this election petition, the lawyers for the IEBCs are coming in to report that actually the IEBC servers have been opened and that they've been an access and that we have had a progress that is around 90%. And then the Azimio or the ODM, the ODM lawyers are coming in to say that, hey, look here, we have been denied access to the servers. And unlike what the IEBC councils would want to portray, we have even come to learn that the server that we do not have just one server, but we actually have 8. So we've been allowed access to one of the servers. We do not have access to the other 7. And then Lenaola, because he's been the one who has been in charge of this ICT system of this electoral process, is telling them, let us wait for the registrar of the Supreme Court, because all of you are giving us conflicting information. We are going to trust what the court would have interrogated and the report that the registrar is going to that the registrar is going to file with us. So, and the report came out yesterday in the evening. So we are waiting because both parties were told that they were each going to be given 15 minutes to speak to the report that has been provided to the court by the registrar of the Supreme Court. So it would be very interesting because the registrar of the Supreme Court is presumed to be the neutral party. It would be very interesting for the parties or for counsels for the parties to then come and interrogate that report and just give the way forward to the court for the court then to come up with the final determination. So we are dealing with so many issues. There are actually so many issues that the court, and that is why you see that the court has to determine, and that is why you see at the end of every submission for either party, the court comes in to ask questions so that then it guides that process. Yes,
I think that is an issue that we also wait to see what the court will be determining. And I understand that the Supreme Court already is getting in to have their sitting this morning in their final day of the submissions and the rejoinders by the petitioners, as well as the responses by the counsel representing the respondents. But just before they get prepared and begin the session now, there's something you've talked about, the technology, and I understand it's Justice Lenaola that's talked about that as well as also Smokin Wanjala. So just take a look at some of the questions that Smokin Wanjala raised yesterday.
was the contract between the IBC and Smartmatic was to supply and maintenance. So if I understood you correctly, this Venezuelan was accessing the server as part of the maintenance. So what is this maintenance? What does it entail? What was he doing there? Say he was released and locked out just before the election. So what was he maintaining in that system? Maybe you just want to tell us what maintenance entails as part of that contract agreement.
All right, and that is Justice Smoking Wanjala and the issues that he raised. Just so quickly, because I understand the Supreme Court has already begun their sitting. What do we expect of today for the agendas and the submissions by the respondents as well, even as we cross over live to the Supreme Court?
The respondents will there are two things that are going to happen this morning. There is the report from the registrar of the Supreme Court insofar as the ICT, Buhula Balu is concerned. Both parties are going to, because they were supplied with the report yesterday. It is expected that they're going to be given 15 minutes to each of them, just highlight the various sections of that report which they think favors their position. That is one. Two, the respondents sought for time to as well answer the questions that were asked by the various judges yesterday. So they will go first. After they are done, then the petitioners would have, a second bite at the cherry insofar as having a rejoinder is concerned. So after the respondents have come in, the petitioners will come in, and then they are going to close the case and leave everything to the court to make the determination.
And for Kenyan who is perhaps watching, what is a rejoinder?
A rejoinder is an opportunity that is given to a petitioner or to a plaintiff or to a claimant or anyone who approaches the court, or anyone who prosecuted the case first. So they prosecute the case first. The other party, in the interest of fairness, is given time to respond. And then now the petitioner or the claimant comes in to clarify a position that may, to clarify a position that may not have been clear as at the time when the respondents were, were responding to their allegations. So if there are any gray areas, then the petitioner is given a second chance, just to polish it and to put the record straight. Unfortunately, the respondents are not given a chance to rejoin. Yes,
I think that is much in order. So I understand right now the pictures that you're seeing on your screens, that is the former Attorney General Githu Muigai, who is now the counsel representing the Independent Electoral and Boundary Commission, just opening remarks and now making the introduction. But the pictures, they are coming live from the Supreme Court, so we cross over live there to be able, to follow on what is happening at the opening stages of the last day of the petition.
Taught us yesterday, added to the votes cast, so that the figures on 34A are not necessarily the figures in 34B and not in 34C. So tell us, as you answer the question in your own manner and style, on voter turnout, was it calculated on the numbers in 34A, B, or C? Senior Counsel, you understand our concern? Thank you very much.
Madam Chief Justice and President of the Supreme Court of Kenya, honorable and distinguished judges of this court, my name is George Murugu. I am here to answer questions that then the bench put to the Commission and to the Chairman. I will be as brief as possible, noting the little time that I have, and I hope that I'll be as useful to the bench as my colleague Mr. Mahat has been. Now, I will straight away start with the questions that were put to the first and second respondent by His Honorable Justice Ouko. And the first question was to do with the question of unutilized ballots and how they are accounted for. This is the way unutilized ballots are treated. At Regulation 69, which provides for the voting procedure, that is the Regulation 69 of the Election General Regulations, it provides that a voter will be issued with ballot papers for all elections in a multiple election, that is at Regulation 69.2. At 69.2a, he is expected to cast his votes in respect of all the elections. 69.3 makes it an offense for a person to knowingly fail to place his or her ballot paper issued to him inside a ballot box. But at Regulation 77e, an unmarked ballot is treated as rejected and is void and shall not be counted for purposes of declaring a result at the polling station. At Regulation 78.3, the presiding officer then is put under an obligation to record in Form 41 the head of rejection for each ballot, and for our purposes, Sub-Regulation 3D then addresses the question of unmarked ballots. Regulation 81B then provides that rejected ballots, such as the unmarked ballots, are sealed in a tamper-proof envelope and placed in the ballot box. That is how they are accounted for, Honorable Justice of the Supreme Court. The second question that I shall deal with, and this again it was posed by His Honorable Justice Mr. Ouko, was whether the appointment of the chairperson as returning officer was as an agent of the commission or as a national returning officer in his capacity as chairman. This is how I would wish to address this question. It is a direct one, and the answer lies in the Constitution. Article 138.10 places an obligation upon the chairperson of the commission to declare the result. So the gazettement was not for purposes of Article 138.3c, but specifically for Article 138.10 to fulfill that role, to take up that responsibility, to account for that result that follows a presidential election. That is the specific purpose for that gazettement. But while I'm on this question, I would also want to pose another question. Would it then mean that if the gazette notice was to fall away, would it then mean that the chairperson of the commission under Article 138.10 would not be in a position and suffer lack of constitutional authority to declare that result? My answer is no. In other words, the gazette notice is purposely to tell Kenyans that the Constitution has rested these obligations upon this office to declare that result. Beyond that, it is superfluous. And I urge Madam Chief Justice and Honorable Justices of the Supreme Court that that particular gazettement should not be read to mean that the chairperson had gone rogue, that the chairperson had taken upon himself and arrogated unto himself a power that he did not have. It is the Constitution speaking. It is in fulfillment of a constitutional expectation and obligation under Article 138.10. If you allow me, my colleague Mr. Mahat Somani will address the other punctuated questions that don't feature in my presentation. I will address the questions posed by His Honorable Justice Mr. Lenola, and this question is to do with the understanding of the state of the law as far as Section 83 of the Elections Act is concerned. And this is our submission, that the law is in a state of flux. Why do I say this? In 2017, the statutory provision that then existed suffered an amendment through Election Law Amendment Act number 34 of 2017, effectively repealing the 2017 provision. Now, the new amendment similarly suffered terminal fate before the High Court in the Katiba Institute case. Therefore, one would be tempted to argue that as far as Section 83 is concerned, we have no law. But in my humble opinion, I would be more kind to the state of the law as it exists. It's in flux. Why do I say this? This court had had opportunity to address questions of what happens to a repealed statute when the replacing statute itself suffers the same fate, in the BBI case. And there was differing opinion, understandably so, because it's not a question that can be easily wrested. In my earlier days, if you ask me, I would say there's no power to animate the previous provision of law. It rested where it did at the point of being repealed or being declared unconstitutional. However, the Constitution provides a mechanism by which we can determine the validity or invalidity of an election beyond Section 83. That safety net is to be found in Articles 81 as read together with Article 86, and specifically for purposes of a presidential election, we must read it together with Article 138(3)(c), which then provides the qualitative test, the process that we then use to arrive at that result to be declared under Article 138(10). So that at Articles 138(3)(c), there is a process of verification and tallying of those results that then come from the polling station and from the constituency tallying centers. All right? Under Article 81, we are then to observe certain principles of the electoral system, failing which then an election can be rendered invalid. Article 86 addresses itself to the voting method and sets out principles that then must be observed in operationalizing that voting method. That is a qualitative test. The quantitative test then is found again under Article 81, or rather 86, 2, where counting is involved of votes cast, and Article 138(4), which then sets the criteria for declaration under Article 138(10). So then it is my humble submission, even as the state of the law remains in flux, there is a standard by which we can determine the validity or invalidity of an election, and that is my humble submission on that point. The second question, Madam Chief Justice and honorable members of the Supreme Court, directed at the first and second respondent by His Honorable Justice Lenaola, was why didn't the chairperson wait until the next day and try to reach consensus and address the 27 constituencies. It is important to point out at this juncture that the 27 constituencies had been tallied and had undergone the verification process, and were ready for announcement by Professor Goulier. My lords and my ladies, I refer the Honorable Court to paragraph 35 of the affidavit of Professor Goulier, filed in the main petition. And as to the circumstances why the chairperson opted to declare the results on the very day that he did, the explanation is to be found in paragraphs 86 and 111 of his affidavit. But if I may summarize, he made considerations concerning security of his staff, who at that particular point in time were suffering arrests, abductions, and injuries to officials, including commissioners. In his mind, it was prudent to conclude the exercise since Article 138(3)(c) had been fully satisfied. And there was a legitimate expectation that the results were to be declared on the 15th of August, as had been announced on that very morning. I'll quickly address the questions that were raised by Honorable Lady Justice Njoki. The term commission used in multiple senses. How do we know which sense is applied when? My quick response: it is a question of the context in which the term commission is used. Section 2(1) of the IEBC Act defines the commission to be the IEBC. Section 11A then breaks it down further to provide that there is that policy organ which is then constituted of the commissioners, including the chairperson, which then tasks itself with oversight, strategy, and policy, and the secretariat that then deals with administrative issues on a day-to-day and executing matters of policy that then the commission, or rather the membership of the policy organ, directed. Therefore, in my humble submission, it's a question of context on how the term is used. What are the checks for this all-powerful chair? For instance, if he was to announce the wrong results or be incapacitated in such a manner that then he could not declare the result. The checks are to be found within the constitutional and statutory framework. Follows. Article 138 then speaks to the checks. Article 138(3)(c) speaks to a verification and tallying process that then engages the commission, the body corporate, so that there is no room for the chair to act as a lone ranger. And while I'm at this point, it is important to point out that in this particular case, Article 138 3C was fully satisfied. My lady, my lords, a narrative has been created that certain commissioners were given roles akin to domestic services. Nothing can be further from the truth. We all saw it. We all saw the commissioners interacting with the results, interacting with the verification and tallying process. We all saw them announcing these results. We cannot unsee what we saw. But then, just to lay emphasis on this, I would wish to quickly refer the Honorable Court to paragraph 40 of the Chairperson's affidavit, Wafula Chebukati, paragraphs 8 and 9 of the affidavits of Professor Abdi Gulier, and paragraph 7 of Boya Molu, who speak to the truth of this issue. Quickly, my lords, on the last question, on the issue of agents and their roles. Agents play an important role in the electoral process. It's up to the parties and candidates to appoint them. But for purposes of Regulation 79(7) and 62(3), the absence of agents does not invalidate proceedings at the polling station. That would be the end of my presentation. Unless the court has any question for me, I would ask to resume my seat. Thank you, and invite Mr. Ma.
My Ladyship, CJ, Chief Justice of the Republic of Kenya, My Ladyship, the Deputy Chief Justice and Associate Justice of Supreme Court, I will try to waltz and do very fast because I'm short for time. I will mention the judge who asked the question and I will give my answer precisely. Justice Ouko asked the question that 33,000 votes, there's a variance of 33,000 votes between governor and president. Nothing could be further from the truth. The variance between the presidential and the governor is 24,000 votes. The same can be accounted for stray ballots. He asked the question, what are the stray ballots all over the country? We have to look at all those ballot boxes to get what are the exact stray ballots in those. But I did a bit of analysis, and I've attached the analysis in Kibra and in Makadara. It is 2 per polling station. And the beauty about this is late last night, I also ran an analysis on the scrutiny report that we were given for the 18 polling stations, the report of the registrar. It exactly tallies. The stray ballots, even for that, it's actually 2 per polling stations, even if you looked at the scrutiny report. That gives you a figure of 92,000, the whole of the country, shared between the different ballot boxes. You cannot be able to know how the exact number of them, but that is the average. So if there's a variance of 10, 20,000, that's within, but anything way above that, you know, that cannot be accounted for by the 92,000 becomes very problematic. And I think I have attached that, and if that could run, the court should look at that. So it's 2 per polling station, 92,000, which is accountable. So if there's a variance of 40,000, 50,000, then the court can question that. But anything within that range, that is within the normal range. The second question that Justice Ouko asked is, do you have any instances where voters walked into polling station and voted for presidential only? No, we don't have. The integrity of the ballot is very important. If someone comes into our polling station, we give him all the 6 ballot papers. He can do whatever we want with them, but he cannot go out with them. He can put it in in the boxes, he can mark them, but he cannot. That's why we're able to account for either through the rejected or the stray ballot. So to the question that someone can vote for one candidate and leave the others, It's not true. It's actually, the regulations don't allow. It's a criminal offense for someone to get out with ballot papers or election material from the ballot box. The second question that has been asked is, Justice Ouko said the voter turnout, you say that there were 45,994 polling stations, out of which 46,299 polling stations were identified through KIMS. So only 235 were identified manually, out of which 6 did not have any election taking place because of violence. 229. I think the number you are interested is how many people voted manually. 86,889. 86,889. And the registered voters in those polling stations is 114,917. 114,917. 114,917. The interesting thing is we provided all the KIMS return. If you look at the affidavit of Michael Ouma, we provided all the KIMS returns. So you can check the KIMS returns as against how many people voted manually. Justice Ouko also asked a question. Justice Ouko asked the question that that is the number of the 86,889. Those are the people who voted manually. So the integrity of this process is very important because the other ones can be accounted for by the kits, right? The second question, Justice Ouko said, Omtata says 1,665,412 people curiously voted when the polls closed and I think this is a faulty analysis, and you really have to understand how the kit works, right? So when you open the polling station, the kit sends a message that we have opened the polling station, we are ready for action. People pass through it, it sends automatic returns. It pings to the nearest network, sends automatic returns over the period of time. If it's not able to get the network, it will keep that information for the next 2 hours. Yeah. So that is how the number changes. The polling will close, but some KIMS will be sending the people, how many people went through, and it's only when we know when all the KIMS have transmitted and we know how many people have voted manually, that you can be able to look at that, to look at it. So polling ends at 5 p.m. There are areas that voting commenced on 6 a.m. on the next day. Some places in Eldas, KIMS reported happens once the network, once it has network, and it requests to connect. So I think it's a false analysis because he says at 5 p.m. we should have known the whole turnout. It's not true. KIMS will keep on giving that information. Justice Lenora asked the information about whether the Form 34C is captured in JPEG and what happens to it. I humbly want to donate a KIMS kit to the court, a training one for the court to see itself. I have given a dummy form, a training Form 34A. I have also given the password. The court can take the picture and actually see what happens. The kit takes the image, and it's on the image that actually the conversion happens on PDF. We don't do any JPEG, and there's a reason for that. In fact, if you look at it, when you are taking the image, it will ask you for the QR code, whether it is proper. It will ask you for the gray scaling, and you will see how we do it. And we do for JPEG because all your phones take JPEG. We want to differentiate our image from the ubiquitous images of JPEG. So that one I want to, through the registrar, I want to donate to the court to see it, a live demo. Justice Wanjala asked the issue of turnout of 65.4. I want to tell this court, at paragraph 30 of the affidavit of the chairman, that clarification was sought and it was given. And the chairman, and there is a video to it actually, the chairman clarified and he said the turnout is not 65.4, it is 64.6. In fact, you will see Martin Nyaga rushing to the chairman, telling him, the person who was in charge of the cumulative of the turnout, telling him, no, that is erroneous. So the number is 64.6 at the point where he made. Is turnout really important in the declaration? I want to tell this court, there is this fascination by the petitioners on turnout. We don't use turnout to determine the presidential election. I think that is the base to start from. The reason why we give turnout is a measure of transparency and integrity to know how many people pass through the kit. And the problem with it is a lot of people don't understand how these kits work. If you look at the numbers I gave on that screen, you will see, in fact, if you look at 2045 hours, 63.6 and 64.6, you will see that the total registered voters on 9th August 2045 is 21 million, under the KIMS 589 961. On 10th August is 21 million 926 565. If you deduct those numbers and you compare to the people who are actually identified by the kids, actually the people who are identified by the kids is more than this number. And a lot of people will say, oh, why do we have more people who are registered in those stations than people voted? It happens. And because the relationship between the people who are identified in the kit and those total number of voters in those polling stations is not a linear relationship in this sense. So 9th August 2045, a kit will report 10 people. So we'll say 10 people have been identified in those kits, but the number of registered voters is 700. We will add in the total number of registered voters. You reached 10th August 240. That kit has already given its maximum registered voters in the original reporting. But people will keep on passing it. When another 20 people pass through, the kit will report 20 people have passed me through. So we will say the voters identified under the KIMS has increased. But we don't increase the registered voters in those polling stations because it is already reported. So the relationship is not one-to-one. And you have to understand, and this is the confusion that is coming, we have to understand, the only way you will know the total registered voters is when all the KIMS have reported. So when all the KIMS had reported, because this is a snapshot of that information in time, when all the KIMS had reported, the voter turnout was 64.7103. So what was remaining that time? Only the manual voters. How many? 86,899. So it's good to understand that, because if someone just looked at this information, you will come with all manner of confusion. So the kit will report, once one voter passed through the kit, we say one voter identified, but the column of registered in that polling station we put 700. But the voters will keep on going through the kit. So as people go through the kit, we'll keep on increasing the voters identified in that kit, but the number of registered voters will remain constant. you can go to the second one. This is the one I was describing. In fact, this one has, it even has the timestamp of their form, JPEG. We don't do JPEG. This form was relayed to them 2 days later. The elevation of the camera. And I have noted all the things that are wrong, the exact same fold. It's an impossibility. I mean, you have 41 polling stations all over the country, and the form they are giving is at the same elevation as what we have given. The picture that our PO took on the background of the Kim's kit is the same. And you can tell, and the reason why we were saying that it's an impossibility is because there's nothing else you can change from those forms. You cannot change the signature of the agents. It's an impossibility. The only thing you can change is the tallying. You can try change into JPEG and try to amend the tallying. And that is really important. That is the crux of this matter, and the court has to look at that and actually make a finding. I will try to also, to Justice Ouko's question about the stray ballots. I just want to mention that the court report bears out the assertion of the IEBC. If you look at the report that was done relating to the stray ballots, I went through the court report and actually tallied the stray ballots. It is 2 per polling station. If you project this to the whole country, there will almost 90,000 stray ballots. And the way you account for stray ballots is they are put in the polling day diary, PSD. I have provided the polling day diary for 2 of the constituencies to just give the court comfort that as IEBC we can account for each and every ballot. To the question that has been asked by Justice Wanjala on the turnout, a clarification was given, and this is the assertion of the petitioners. They are saying, we are not interested in the clarification given by the chairman. We are going to take that turnout of 65.4 as against the total registered voters, okay? Then come to the conclusion that there are votes that are unaccounted for. And we are telling him that is not how we do it. Okay? Turnouts, we give the number of people who either have passed through that kit at a snapshot. Okay? And there's nothing much about it. The declaration is made on the actual physical ballots that we count. We count the physical ballots. After counting the physical ballots, we tally it. Madam DCJ asked about the rejected ballots, whether they are different from the rejected. So the way we calculate turnout refers to the number of people who have passed through that polling station in the 46,229 polling station in the Republic. We have not even reached the issue of rejected ballots or anything. It's how many people appeared that day. So we have a number. Then we do the counting. After counting, we get rejected ballots. So how do we determine 50 plus 1? We will say, okay, what are the total votes cast? And we will refer to the 2013 and 2017 decision of this court that said rejected ballots are not a choice of preference and the same have to be removed. So the idea that turnout is affected by rejected ballots or doesn't matter, it's just a measure of transparency. And you have to understand how the reporting of the KIMS happens for you to be able to do. We only give what we can at the time, and we'll keep on doing that. With those
Thank you, Councillor. You're not even being heard. But thank you for answering our questions. On the kit, please deal with the registrar of the court. Thank you for your assistance. Your time is up.
And thank you. And the slides are from our affidavits. They are available for clarification to the court. Thank you.
My lady, I do not know whether you can give me 2 minutes to respond to Lady Justice Jokindong.
You're not helping me to do my days work very nicely.
I'm sorry.
But 2 minutes would mean 2 minutes.
Yes, please.
So that you don't go away saying you are not heard.
Thank you very much, Deputy Chief Justice. The Honorable Justice Jokindung wanted to know from me of my personal experience as a draftsman of the original Constitution, what our intentions were when we created independent commissions. And my simple, straightforward answer is, we were trying to create greater autonomy and functional independence. You will recall elections, for example, were under the Attorney General's office and were under the hands of a person called the Supervisor of Elections. And that had been not very successful. What did we achieve? The one thing we achieved is that we created independent commissions that do not function in the same way. For example, this commission, the Electoral Commission, the chairman has executive authority, because this is one of the very few commissions where the commissioners themselves do some actual work. This is very different from EACC. EACC, the chairmanship is not executive, and the commissioners do not do executive work. They cannot determine to charge anybody or to investigate anybody. That is a work done by management. Here, as we have seen, this commission is extremely hands-on, and for that very reason, its chairman has executive power. It is very similar, Milady, to the JSC, the Judicial Service Commission, which in theory is a corporate body. In day-to-day functioning, the Chief Justice has executive authority and makes many, many decisions in the name of the JSC, as it should be, because it couldn't be run in any other way. Thank you.
We thank you, the Honorable, the AG, Senior Counsel. Thank you very much. At this juncture, I return this to the Judge President to lead the proceedings.
Yes. Yes, thank you for that session. We are really mindful of the time today because we wanted to finish these proceedings at least by midday. We had allocated the petitioners, the main petitioners, 1 hour to do the rejoinder, and then the other petitioners were allocated 15 minutes. So this is the time now for the main petitioners, the team led by Senior Counsel Honorable Rengo.
My Lady, the Chief Justice, before the main